Your Second Amendment rights can disappear in less than a day. No trial, no conviction, just one phone call or one signature from a judge. Right now, there are 6 completely legal mechanisms that can strip you of your gun ownership before you ever step foot in a courtroom. Most gun owners have no idea these back doors exist until federal agents or local police are at their door with a court order demanding every gun, every magazine, and every round of ammunition you own. I'm going to walk you through all 6 of these hidden traps. None of them require a criminal conviction, only paperwork, a judge's pen, or a single report. By the end of this video, you'll know exactly what can take your rights overnight, and real-world examples of how it's happening right now, and precisely what you must do the moment one of these hits you. Last month alone, thousands of Americans lost their firearms without ever being charged with a crime. This is not theory. This is happening every single week across the country. Number 1. Ex parte. Emergency protective. Orders. Someone, your ex, a neighbor, a disgruntled family member, walks into court, tells a story without you present, and a judge can sign an order that forces you to surrender every firearm you own within 24 hours. No notice, no chance to speak, no cross-examination. Under 18 U.S.C. Paragraph 922G. 8. Possessing a gun while that order is active is a federal felony, up to 10 years in prison. The full hearing might be 2 or 3 weeks later, but your guns are gone the same day. I've watched vindictive exes weaponize these orders for years. One guy spent $18,000 in attorney fees and 8 months getting a bogus order thrown out after he had already lost his carry permit and his entire collection. What you do: document every interaction in messy relationships or disputes. Save texts, record calls. Where legal, keep witnesses. If you get served, comply instantly. Hiding even one gun turns this into a slam-dunk felony. Hire a lawyer the same day and fight like hell at the return hearing. Temporary orders are easy to get. Permanent ones are not. Number 2. Involuntary mental health holds. 72-hour evaluations. You make a throwaway comment about being depressed, a friend calls for a welfare check, cops show up, decide you seem off, and you're transported in handcuffs for evaluation. That involuntary commitment gets reported to NICS under 18 U.S.C. Paragraph 922G. 4. And you are now a prohibited person for life, even if doctors release you 48 hours later saying you're perfectly fine. I personally know multiple veterans who sought help for PTSD at the VA, got flagged, and permanently lost their gun rights. One of them was a decorated Marine who never even admitted overnight, just observed for a few hours. What you do: be extremely careful what you say to doctors, therapists, and police about mental health. If you're ever taken in, demand a hearing immediately. Most states give you that right within days. Know your state's restoration of rights process. Some are reasonable, others are almost impossible. Number 3. Old domestic violence misdemeanors. Lautenberg Amendment. That stupid shoving match with an ex-girlfriend in 1999? The plea you took to make it go away? Under the Lautenberg Amendment, there is no expiration date. Any misdemeanor conviction that has use or attempted use of physical force against a current or former dating partner, spouse, co-parent, etc., makes you a prohibited person for life. The definition keeps expanding. Many states now include dating relationship, even if you never lived together. Guys find out they're prohibited when NICS denies them, then panic and try to sell their guns, only to get raided because ATF already knows they possessed firearms after the disqualifying conviction date. What you do: pull your criminal history from every state you've lived in since age 18. If you discover a qualifying conviction, talk to a firearms attorney about expungement, set-aside, or pardon options before you touch another gun. Never, ever lie on question 21.f of the 4473. Number 4. Being an unlawful user of controlled substances. Marijuana, Adderall, pain pills, etc. Question 21.e on the 4473 is crystal clear. Are you an unlawful user of or addicted to marijuana or any other controlled substance? Marijuana is still Schedule I federally. Medical card, recreational state, doesn't matter. Any use, is prohibited person. ATF has repeatedly stated that even state legal marijuana users are prohibited. Lie and buy, 18 U.S.C. Paragraph 922A, X, making false statement, up to 10 years. Tell the truth, or you're denied, and now ATF knows you possess guns while using. I've seen people lose everything over one THC gummy found during a traffic stop. What you do? Zero tolerance. If you choose to use marijuana or any non-prescribed controlled substance, you cannot legally possess firearms under federal law. Period. No exceptions. No, it's just CBD. No workarounds. Number 5. Red flag, extreme risk protection orders. 21 states, and counting, now allow family, household members, police, and in some states even co-workers or school officials to petition a court to take your guns because they claim you're a danger. The scariest part, the initial order is almost always ex parte. You're not there to defend yourself. Judge signs, cops show up, guns gone. Violation of the order is usually a felony. Orders can last a year and be renewed forever in some jurisdictions. I've seen these used as weapons in divorces, inheritance fights, neighbor disputes, you name it. What you do? Total compliance the moment you're served. Hire counsel immediately and prepare a brutal defense for the full hearing, usually 7 to 21 days later. Bring witnesses, texts, medical records, anything proving the petitioner is lying. Number 6. Federal felony indictment. The second, a federal grand jury indicts you for any crime punishable by more than 1 year, you become a prohibited person under 18 U.S.C. Paragraph 922N. Conviction is not required. Indictment alone does it. Many people don't voluntarily surrender their guns because they're innocent until proven guilty. Wrong answer. Federal agents will execute a search warrant, find the guns, and now you're looking at additional 922G, E1, charges on top of whatever you were originally indicted for. I've watched clients turn a 5-year exposure case into a 20-year exposure case because they kept their collection after indictment. What you do? If you have any reason to believe you're under federal investigation, stop possessing firearms immediately or transfer them legally to a trusted person. The moment you're indicted, surrender or transfer every gun within 24 hours. Do not play games with this one. Quick recap of the 6 overnight traps. Ex parte protective orders, involuntary mental health holds, old domestic violence misdemeanors, no expiration, any use of marijuana or controlled substances, red flag, extreme risk orders, federal felony indictment. Any one of these can take every firearm you own before you ever see a jury, and several of them can put you in federal prison for possessing what were perfectly legal guns the day before. Know these 6 traps cold, because ignorance isn't a defense when the ATF knocks. If you want to stay armed and stay free, hit subscribe and turn on notifications. Next video drops the 94473 mistakes that get first-time buyers investigated by the FBI, even when they did nothing else wrong. You do not want to miss it.